So, how are we feeling about this English law series so far? I know it's a lot to, intake, and there's a lots of new words that, of course, you haven't heard before. But, of course, the end result is exactly what most of us wish to arrive at within our lifetimes, and most definitely for the benefit of our lineage and future generations. So I'll begin what I have written here. We have journeyed into the English law system in order that we can then better comprehend the goings on today as relates to our rights and how they relate to land, estates, and property. Our purpose is to arrive at finally reaching the point of being in our own right, sui juris namely, thereby have us actualized and so noticed in our natural state that then has the power over all titles and their perpetuity instruments. This will be accomplished when each individually comes to their own realization that the law is perfected. There is nothing more to add, but rather waiting for each of us to exercise our own true power. It should now be understood that the power that monarchs, the church, territorial governments, and their courts have over the people today is a result of the agreements they have with the land interest, to which these authority figures are said to manage according to the type of land interest the law has given them a duty and power to administrate over, and so it is rather the land agreement that then gives each of these concepts, these corporation souls and institutions, their power to enforce rules over every action as we as individuals then pursue. I think it prudent to provide a brief overview of the basics of the evolutions of land law, so as to arrive at the topic of this video, which is the Settled Estates Act 1856, the C as the acronym, whereby it will be no more than a mere mention of this act so as to assist us to inculcate in our own minds the importance of non-competing subject matters. Territorial governments, we have learned, have a second level of use to land, which is subject to a trust rules and a trust. All historians, law professors, and judges can agree become realized through the advance of the beneficial use to land. That was initially constructed so as to circumvent the common law held immediately by the king. The use, originally introduced through the Roman civil church, was in opposition to that of the king's land interest, and we can begin to see evidence of these different interests to land in section 43 of the Magna Carta as an example, which began to develop a set of rules on how his interest, though secured in the common law, which was still evolving at the time, was to be considered when fiefdoms concerning portions of land first held in right of the king were to be made for the use of the church. By the late 14th century, uses had evolved to avoid feudal incidents and creditors. One main way this was accomplished was to transfer the legal titles into a group of feoffees, so that before legal title holder could use to his benefit the fruits of the land using the status of the sesuique use. This action of transfer into a feoffee or feoffees was not a creature of oddity within the kingdom itself. When knights went off to provide service to the king in war, they had to temporarily transfer the legal title into a feoffee or feoffees, so they could legally manage these feoffees, the manor, in the knight's absence. This type of transfer became customary within the realm, and so with its introduction, new problems and conflicts arose between the sesuique and the feoffees, those acting as trustees as we know them today, in which the feoffees, who were only governed under the wishes of the grantor, began to ignore these wishes since the common law could not interfere with these new equitable interest. The king's ear, the chancellor, a man of the church, was then exercised with a new duty and power to travel among the realm so as to settle disputes between Feoffes and the Seswickee use, so as to maintain the peace essentially, which, as these titles and so disputes grew, so did the duties and powers of the courts of chancery over these equitable interests, which, in notice of being repetitive, were of different subject matter that could not be entertained within the king's courts. Reading from the Cases and Notes on Land Law, authored by Bora Laskin, he states on page 361, chapter 4, at the bottom of the page, quoted to say, when Chancery for the first time enforced a decree in favor of a Seswickee use against a Feoffee, the first recorded one was in 1446, we had the beginnings of a new scheme of interest in land, especially with the recognition of such features as inheritability and assignability of the beneficiary's interest and the recognition of quantums of interest comparable to the estate system at the common law. And then Bora Laskin continues, in time the use or beneficial interest became enforceable in the Court of Chancery, not only against the Feoffes to uses, but against their heirs, their donees, and even against their assignees for the value of the notice. Unquote. The Statutes of Uses 1535, which was thought to do away with the use altogether, actually paved the way for the land to now be transferred through documents instead of livery of season, through the enacting of the statute of enrollments that now began the registration of these new uses, and so the gateway to now establish trusts, which were recognized when the trustees themselves played an active role. Trusts developed and gave more powers and duties to Parliament that then created legislation over a set territorial grant, held first under a trust instrument, which evidenced not only the separation of the common law legal title from the equitable interest, so as to ensure either party was safe from any overreach or conflicting liabilities, but to give the courts of chancery the power to build and involve the right to purchase these equitable interests as a legal title within their own right, so as to then make them available to those who could never control a common law legal title, being that these settlements were often too large of a settlement, but also these settlements were often transferred through the laws of inheritance and for the benefit of certain bloodlines. These equitable use titles, now legal as mentioned earlier, in their own right, and so not immediately under the liabilities of the common law legal estate, allowed for the first time tenants to now become assumed owners, to now control a legal title through device, gift, and sale, to which later evolved to a fee simple absolute rights traded as title deeds today, whereby they could control these titles as a means for profit, being that this purchase was good against all the world according to the value of the security developed, cultivated, and nurtured through territorial legislation, much like the rules governing manners of yesteryear, those controlled by barons and the manorial courts of their time. This preemptive overview will now serve as a formal segue, which will be much longer than the time I will spend on the Settled Estates Act 1856 itself. For the main reason, the C only serves to prove the differences of subject matter, and so highlight our only interest. I also want to remind everyone following this series so far that no matter who holds any interest in land, they must first be used in the capacity of a tenant for life, and so next using a particular legal personage that then determines one's status. I will first read from the preamble of the Settled Land Act 1882, in which I referenced in the previous video. The Settled Land Act 1882, Chapter 38, the 45th and 46th year of the reign of the Queen Victoria, states, an act for facilitating sales, leases, and other dispositions of settled land, and for promoting the execution of improvements thereon. Now, before this act, if you were to type in the search bar Settle Land Act in the legislation.gov.uk website, you will notice before the 1882 Act a list that links one to a series of written transfers made amongst legal estate holders of the time, which, of course, were before necessary so as to allow conveyance of these type land interests, and why it became prudent to draw up an act so as to curtail human error in documents through its promulgation, so as to simplify transfers among people. But, more importantly, the Act allowed the court to condense the litigation necessary if the judges, now lords, have a codified set of rules so as to base their determinations upon. Of course, this serves to speed process, promote consistency, and reduce human error. Do we all enjoy conveniences today? As the world trade became more accessible, the need for expedient determinations became a predominant concern of not only lawmakers and the courts, but of the kingdom as a whole, so as to maintain the peace. And when it comes to money, the commodity of time is heavily valued. The Settled Estates Act 1856, I will now read its preamble, which is giving the court the powers and duties over a particular legal interest. Beginning with the purpose of the Act itself, the introduction first reads, an Act to facilitate leases and sales of settled estates. The preamble next reads, whereas it is expedient that the courts of chancery should have a power in certain cases to authorize leases and sales of settled estates, where it shall deem that such leases or sales would be proper and consistent with a due regard for the interests of all parties entitled under the settlement. What is a settlement? The Settled Land Act. So we can obviously now conclude through proper deductive reasoning that the Settled Estates Act 1856, grants the power of administration over the sales and leases of settled estates under the settlement to be administrated through the high courts of chancery. So that equitable interest, namely, in which we had learned evolved from the original use, traced back to the church who built the bar union therefrom, built such landmark institutions of Oxford and Cambridge, that then became the vehicle in which to debate issues, negotiate deeds, and secure the rights of these type of equitable interests under a trust instrument. We are only interested in what exactly? The common law legal estate? That estate settled in the land's interest secured through warranty titled the Settled Land Act, which is purposely separated from those interests administrated through the courts of chancery and so subject to the rules of equity. So, if you hear of anyone speaking to his rights through constitutions, his right to a lawyer-regulated property interest, who also may be cherry-picking scripture so as to excite some sort of certain right, any individual or group who is speaking to matters of setting off mortgages, to not have to pay taxes or utilities and loans and such, whom is speaking to, promoting, or is selling documents that claim to exercise some sort of personal power, etc., etc. What will this mean exactly? And with that question, I will end this video, so as to allow it to percolate within your own mind. And do you like this video and find this info important for all to learn? As a reminder, the more action through hitting the like and sharing with others will serve us all through helping us form groups to create discussions in how we can quickly execute our true inherent rights, which is mentioned before, is subject to the Settled Land Act 1925. And with that, thank you for listening.